Back on the record, this is the people of the state of Colorado versus James Egan Holmes, case number 12 CR 1522. The record should reflect that Mr. Holmes is present with his attorneys and the prosecutors are present as well. We continue to be outside the presence of the jury. The jury, as my bailiffs were about to bring in the TV/DVD equipment, indicated that they were about to send another note, and here is the note. We're going to mark this one as question number 3 during the jury deliberations of phase 1 of the sentencing hearing. Our hours will be 8:30 to 4:30, 8:30 a.m. to 4:30 p.m. each day for the remainder of deliberations. And then in parentheses it says, in all phases. And then it's signed by the foreperson. So they asked my staff that they bring the equipment back tomorrow. So they're on their way. They're about to go home here. We're about to release them, and we're going to release the alternates as well. Let me just make one other record. In terms of the discussion that we had related to DiBella, related to Frasco, related to Jefferson, and that line of cases, the law in Colorado as it stands now is that the rule that I've talked about that is explained in all those cases does not apply to a defendant's videotape statement. And that case is People versus Ferrero, Ferrero, A74 Pacific 2nd, 468. That's a Colorado Court of Appeals case from 1993. So the rule doesn't apply to, and when I say the rule, I'm referring to the rule that I'm relying on to order supervised view, or excuse me, not supervised, but limited viewing of certain videotapes and CDs. The rule does not apply to either the videotape statement of the defendant to Agent Apple and Agent Mel, and it doesn't apply either to the audio tape statement by the defendant to Detective Apple and Agent Gumbiner. Having said that, I still think the most prudent course of action is to proceed as I am. And so I stand by the answer that I said I was going to send back to the jury, and that answer has been sent back, and I think that is the appropriate way to proceed. All right, is there anything else that we need to talk about at this time on behalf of the people? Mr. Brockler.
Would the court like to pick up the PowerPoint in anticipation of what we may do tomorrow?
Yes. Thank you. Yes, please. Thanks for reminding me about that. I have reviewed the PowerPoint presentation, and because Ms. Higgs was not aware of the rule that I passed today, I'm going to say that it is exempt from my rule. So it would be unfair for me to apply the rule to her when I just passed the new rule today. So go ahead, Mr. Brockler, what are your objections? And has this been marked yet? We should probably mark it so that there is a record of it.
Yes, sir.
What is the next court trial exhibit? 100. Okay, it will be marked as C-TR-100. Mr. Brockler, you may proceed.
Your Honor, and unaware of the rule too, with the court's indulgence, I may have a small 200-300 slide presentation for tomorrow. I'm kidding. I don't have any. But I do have a question about clarification about that moving forward before I address Ms. Higgs. One is, as the court may recall from what I did in the closing statement, once the jury instructions get finalized, I like to take them and highlight certain aspects of them, whether it's elements or words, and put them into the PowerPoint. With the court schedule and with that rule in place, I guess I would ask for some flexibility with the court in terms of slides that deal specifically with the addition of finalized instructions as they appear on those documents, if the court would be willing to permit me at least that. The other parts, of course, I'll get to the defense.
Yes. I don't think I've heard a single objection by anyone to a slide that contains either an instruction in its entirety or part of an instruction. I don't think that's ever a concern for either party, so I don't have a problem with that. And that rule applies now to, that exception I should say, applied to both sides, obviously. Ms. Robinson, someone lost something, a juror lost something? Okay. All right. If they left it here, it belongs to the courtroom now, as far as I'm concerned. All right, Mr. Brockler, go ahead.
Your Honor, this is a presentation that looks like it is comprised of 8 slides. I have no objection to the first slide or the 8th slide. Slide number 2, Your Honor, appears to be straight-up argument. It looks like, I'm not aware of an exhibit that's going to be admitted during the mitigation phase that contains this. It looks like a motivational poster that has the sun appearing over some clouds with the words "rise above" written across from it. That seems to me to be inappropriate for the 2-minute opening statement that the court has provided us. The next slide also appears equally to be argumentative and contains images and a color scheme that I don't know if it's going to be admitted or not, Your Honor, through any witness, but it seems to contain a previously unadmitted exhibit, and it seems to me to be argument as well, especially given the highlighting with the line of one particular square amidst, it looks like a kind of a bathroom style of tiles across there, Your Honor, and then the arrows. The following slide, again, Your Honor, appears to be argument, but maybe they'll have an explanation for how that exact set of words will come into evidence. The next slide, Your Honor, appears to be a truncated and therefore inaccurate statement of the law. It appears to be that they have taken that poster that the court permitted us to use during voir dire, and that they have highlighted one small portion of it which is not an accurate reflection of the law that the court is going to give. And in that way, it also appears to be argumentative. And I think because the court allowed the defense to use this during voir dire, it becomes somewhat misleading about the authority for it. The next picture appears to be a collage, may not be the right word, but 5 separate family photos covering, it looks like, a good chunk of the portion of the defendant's life. I think to the extent that these photos are going to be admitted, and they likely have a good faith basis to believe they are, I do not have an objection to that slide. The following slide contains 3 words. The last word is mercy. I believe the court will instruct the jury on the appropriate use of mercy. I think it will do that even in its introductory instructions. The other 2 words do not appear, I believe, in any instructions that the court intends to give, and they therefore appear to be argument in advance, not what the evidence will show, but in advance of the presentation. And those are my objections to those slides, Your Honor.
All right, thank you. Ms. Higgs?
Thank you, Your Honor. With regard to these slides, I will note that with the exception of the slide with the family photos, these are demonstrative slides. We anticipate that the photos will be coming into evidence. The court is aware that the opening statement, we are allowed to use demonstratives to sort of show the jury what it is that we are talking about. With regard to the last slide, I think that these are all things that the jury is allowed to bring into the courtroom in consideration of the mitigation that we present. So this is not argument. This is part of what the jury will be doing in this phase of the trial. With regard to slide number 5, my preference actually would be to use the board to have your staff bring in the actual board that we use during the course of jury selection to point this out to the jury. And this slide actually shows the full board, but then just sort of brings out step 2, because part of what I am allowed to do in the opening statement is talk to them about how we're presenting mitigation, what that mitigation is. As far as slide 4 goes, this is based on evidence we anticipate will be admitted during the course of the trial. and slides 2 and 3, again, are demonstrative in nature. And these are issues, with regard to slide 2, issues that we discussed with the jury in jury selection. I anticipate this testimony with regard to the difference between serious mental illness and the narrow definition of insanity. That's what this slide represents. We anticipate that testimony to come out during the mitigation phase of the trial, and so I think that this is representative of evidence that we have a good faith belief will be presented during this course of the trial, and there's significant reason to believe that, because that was also part of the testimony that was discussed by the experts in the merits phase of the case, because the shift now is away from the insanity concept, and that's something we discussed at length with the jurors, about someone being able to be sane but seriously mentally ill in the jury selection phase of the case, and that they can still consider mental illness as mitigation even in light of those findings. And so I think it is important for the jury to be reminded of that, and that we will be discussing mental illness now in the context of mitigation. I don't believe I have any other points to make with regard to that PowerPoint, except for this note that I'm getting from Ms. Nelson. Oh, and Your Honor, yeah, Ms. Nelson is correct. With regard to slide 2, which is sort of the theme, that was part of the theme that we presented in the opening and the merits phase of the trial. It's part of the theme that we are pulling throughout this whole trial. It's not argument. It is basically us being able to present a theme of our case, which we are allowed to do in opening statement. It is not discussing law. It is not an appropriate legal argument. And I would note that it wasn't objected to in the merits phase opening as well.
What does that refer to, rise above? It says rise above.
Correct.
It shows, it's a picture taken from above the clouds. It shows the sun. What does that refer to?
So one of Mr. King's themes in his opening of the merits phase of the case was this idea of reaching higher ground, rising above, to be able to separate oneself from sort of the emotion, the inappropriate emotion and attachment that we've talked to the jury about that they're not supposed to have. And so this demonstrative represents that theme. Does the court have any additional questions?
Yes, the slide that says serious mental illness, you said one of your experts is going to say that this is an accurate representation of insanity as it relates to serious mental illness, an accurate graph, is that right?
No, what I'm saying is this is a demonstrative of the concept that insanity is a narrow part of mental illness. That was something that was discussed in the merits phase of the case by several doctors, that insanity is just a narrow focus, whereas serious mental illness can be much larger than that. It's actually also something that the prosecution noted, and it's something that we discussed with the jury at length in individual voir dire. So this is just a graphic representation of that concept, and we are allowed to use demonstrative slides to represent concepts without them actually being able to be introduced into evidence.
All right, is there anything else? Mr. Brockler, it's your objection. I'll let you have the last word.
Thank you, Your Honor. I think it sounds like in the discussion that this is really just a theme that they want to replicate. One, I don't remember any clouds in Mr. King's opening statement. I don't know if rise above was something he said or if it appeared in his opening, but that's neither here nor there. The court will recall that it made us, on a victim impact video, remove things like rainbows and clouds and stuff like that because of the potential prejudice here. And this feels like more than thematic. This feels like an argument, and I think Ms. Higgs concedes that when she says what we want to remind the jury is to rise above and to separate themselves. That's not what the evidence is going to show. That's not what the court instructs them to do when it's giving this instruction. That feels like, at best, it may be available to them in argument, but not in an opening statement that the court has described. This idea, too, with the third slide, that a demonstrative exhibit, because it demonstrates something, therefore they're allowed to publish it to the jury in the form of an opening. Judge, I think what the court was struggling to get from them was the idea of, is someone going to lay the foundation for this demonstrative exhibit? Simply announcing something as demonstrative doesn't make it so. And it sounds like no witness is going to provide any foundation for this to be presented to the jury as an exhibit. We're just going to say this highlights what we believe the argument to be. And the problem is, this, the way they've displayed it, is it appears to quantify what insanity is in the scheme of serious mental illness. And in the absence of testimony to provide further foundation, it's not only misleading, but it is argumentative, and it would not likely be displayed to the jury at any time as demonstrative. Judge, I don't think that, and I've skipped over the slide that says but for. They've said that they think a witness is going to testify to that, and they have a good faith basis to believe that. That is what it is, I guess, Your Honor. In terms of the next slide, which deals with step 2 mitigation and the request to bring out to the jury the instructional for purposes of voir dire poster, Judge, that's not appropriate. This court has moved past the general concepts that would be described to the jury for purposes of determining who could sit on this case and to facilitate questions about them so that they have an understanding of the process. We are now instructing them on specifics of the law, and this isn't it. This isn't what the court's going to instruct them, and it's not appropriate, I think, Judge, to bring it back out and to allow them to reference it either on the slide or with the poster board. And then I didn't understand Ms. Higgs' argument, respectfully, Judge, about jurors get to bring compassion and understanding with them into the jury box. That's been true, I suppose, without being spoken in every phase of everything ever, but that's not what the court's going to instruct them on. The court is going to instruct them on one of those words, and that word is mercy. And to the extent that they think that this slide with the word mercy will help them to describe for the jury what evidence they will see, that's one thing. But they're not allowed to argue to them how to view the evidence, what weight to give the evidence, or any of these emotional words that they want to bring to them before they start to hear the evidence, Judge. Other than those things, Your Honor, it still feels like slides 1, 8, the but-for slide, which I believe is slide 4, and slide 6 are the only ones that remain that are not objectionable, Your Honor. Thank you.
All right, thank you. In terms of the first slide, I agree with Mr. Brockler that this is an inappropriate slide. This is not appropriate for opening statement. It may be a theme that the defense wants to pursue, but this is a picture that, as I said, appears to be taken above the clouds with the sun shining in the background, and it says rise above. And and then apparently the defense plans to tell the jury that they need to rise above any emotions that they may feel and things to that effect. My recollection is that counsel wanted opening statement or an opening statement in phase 2 because they wanted an opportunity to introduce to the jury what mitigation they were going to be hearing about. And I felt that that would be helpful, that it would be helpful for the jury to know what mitigating factors to expect evidence on. It would be helpful, frankly, for the court, and frankly, I think it would be helpful for the parties to hear that in advance. That's why I granted 2 minutes to each side for an opening statement. It wasn't so that a slide that says rise above could be shown. In terms of the next slide, the problem I have with this, the concern I have with it, and this is the one that has insanity, and insanity is one tile, and then the rest of the tiles in this large circle appear to be serious mental illness. I think that this gets into the law to some extent, and it gets into the definition of insanity, and it gets into the role that mental illness plays in relation to insanity. And I don't know that this is an accurate statement of the law. And given that apparently there's not going to be an expert who is going to say that this is an accurate diagram and an accurate representation of insanity within the world of serious mental illness, I have some concerns about this confusing the jury or misleading the jury. And I also have concerns that this is part of the province of the court. It is the court's duty to instruct the jury on the law, so I will sustain the objection with respect to that. The next slide, but for serious mental illness, this would not have occurred. This has been a theme throughout for the defense, and I think it's appropriate, and I will allow that. The next slide, in terms of the request to have the board here, I don't think it's appropriate for the opening statement in phase 2, because the opening statement for phase 2 should focus on phase 2, not on the entire sentencing hearing process. That's number one. Number two, to the extent that the jury is going to be shown anything related to the process or the law that applies in a sentencing hearing, it should be consistent with my instructions. It should be the words that I'm using in the instructions. The part that says step 2, mitigation, any reason for a life sentence over a death sentence, I'm not sure if that's exactly how I'm saying it in my introductory instructions, but it's fairly close. But what I would request is that whatever words I'm using in my instructions is what counsel used so that we don't confuse the jury. So in general, I don't have a problem with a slide that even shows phase 2 in the context of all the phases, just to show where phase 2 fits in. I don't have a problem with that. But use the words that I'm using in my instructions, and specifically, for example, this says step 4. There is no step 4 in the instructions that I'm giving the jury, so that should be avoided, again, so that the jury doesn't get confused about there being a step 4. But to the extent that it can be modified, consistent with the comments that I just made, I don't have a problem with a slide that shows, look, here's phase 2, here's where it fits in relation to the entire process, and here's what phase 2 is about. And obviously, the comment should be related mostly to phase 2. It should be focused on phase 2, but it can be placed in context of the entire 3-step process or possible 3-phase process, just so the jury gets the picture. The next one is one that says James Egan Holmes, and it has 5 pictures. Ms. Higgs is representing that these are going to be introduced, and I don't have a problem with those being shown in opening statement. And the final one says compassion, understanding, and mercy. It seems to me that compassion and understanding is part of mercy. And what I don't like about this particular slide is it makes it seem like these are 3 separate concepts. I don't believe that any of my introductory instructions talk about compassion or understanding. I don't believe that the law refers to compassion and understanding. And again, I worry that we're going to confuse the jury, and so we should be consistent with my instructions. If you want to include mercy, and if you want to say that compassion and understanding are part of mercy, I think that's fair. But to set them apart as though they're 3 different concepts, and these are 3 concepts that the jury can consider in making decisions, I think is problematic, because I don't think it's entirely consistent with the instructions that I'm going to be giving the jury in terms of the law that applies. So those are my rulings with respect to C-TR-100. Is there anything else at this time on behalf of the prosecution, Mr. Rockler?
No, sir, thank you.
Is there anything else on behalf of the defense, Ms. Higgs?
Yes, Your Honor, I'd asked the court to give the prosecution a deadline. We were able to give them our PowerPoint, and they were able to have it for most of the afternoon. I don't want to get theirs at 8:30 tomorrow morning and have to be arguing it at 8:31, so I'd like to have some time frame for that, please.
Are you using a PowerPoint presentation tomorrow?
No, sir.
Or for your opening statement, if there is a phase 2?
No, Your Honor.
Okay, all right, so there's no PowerPoint presentation. Great.
Thank you.
All right, thank you.
I think Ms. Nelson has...
Oh, one more thing, Ms. Nelson, and Mr. Orman, remind me that when deliberations are over with respect to phase one, I need to bring in juror 737 just to finalize the discussion we had about the Newsweek issue. And I just want to make sure he knows that I've taken appropriate action. I'm going to leave it general because I think that's appropriate, but I want to make sure you remind me to do that, okay? Ms. Nelson.
Yes, Your Honor. Just along the same note, I wanted to submit the printout of the website from inagist.com that had captured the Newsweek tweet as a court trial exhibit. I've marked it CTR 101, and I will provide that to your staff.
Okay, thank you. Anything else, Ms. Nelson?
Not from the defense.
Okay, great. Have a good evening, folks. I'll see you tomorrow morning. The court will be in recess. Thank you.